Please be seated. We'll hear argument in 2451, Energen Resources against Wallace.
May it please the court, Mr. Clinton will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. In enacting Chapter 95 of the Texas Civil Practice and Remedies Code, the Texas legislature made a policy decision. And that policy decision was that generally, as between owners of real property who hire independent contractors and the independent contractors they hire to construct, renovate, improve, or modify improvements to real property on that property owner's land, it is the independent contractors who are in the better position to assess and reduce the risk of injury and harm. So the Texas legislature did not abrogate such a claim, but instead imposed a heightened evidentiary burden on claims in which an independent contractor sues an owner of real property in Texas for an injury that arises out of either a use or a condition of the very improvement that the independent contractor was hired to construct, repair, or renovate.
Isn't that where the confusion comes from? In this case, it seems like because we've got condition and use in there, that's where we get confused, because you could say, for example, that the negligence claim arose from the condition of the water well that the plaintiffs were working on, but then that their allegation is that condition was in turn caused by a negligent activity, a use at the oil well, which they were not working on. So if both of those things are true, then does Chapter 95 apply or not?
Absolutely, it would apply, because Section 95.002(2) says that the claim must arise from the condition or a use of an improvement.
But it also says the claim. So are those two separate claims, a negligent activity claim and a premises liability claim?
Not at all. This court has said countless times that we look to the true nature of a claim to determine whether or not it is subject to a particular defense or whether it's subject to a particular act. And so we look to the true nature of the allegations. We don't look to the plaintiff's particular characterization of the allegation.
Go ahead.
No, you go ahead.
That seems right, but that seems to have come up for the first time in the Court of Appeals. I read the pleadings in the trial court and the summary judgment motion, and there was never a ground for summary judgment that this was a premises liability case and not a negligent activity case that would give anybody notice that they needed to put on evidence about whether this was a contemporaneous activity or whether it had come to rest or anything like that. So can we really answer that question on this record, and have people had notice to develop the record adequately on that point?
I think absolutely. The motion for summary judgment is a motion for summary judgment that says Chapter 95 applies.
Right, and the reason it gave for applying to the oil well is that there was an activity over there, and so Chapter 95 also would apply. But the reason you're giving on appeal is that there was a use going on at the oil well, so it would also apply over there. But the reason you're giving on appeal is that you can't look at the oil well at all because this is a premises liability case and not a negligent activity case. And I just don't know whether we have the record to know whether the contemporaneous activity at the oil well had come to rest so that this was just a premises liability case.
Well, with respect to the motion did say even if something had come from the oil well, that the claim is one for a condition on the water well. So that is within the motion for summary judgment briefing, and it did absolutely put them on notice. And what this court has said repeatedly with respect to Chapter 95 is that once Chapter 95 applies, and it does apply here based on the very facts as alleged by the plaintiff, which is that there was a condition of the water well from which the injury arose.
That's not what I'm not understanding, because it seems to me that argument is ignoring the term arose from. The use or condition of the water well was nothing would have happened. There would have been no injury just from that. What happened was it arose from what happened at the oil and gas well that then caused that, whatever happened underground, to heat this up to cause the explosion, right?
Well, first of all, there's absolutely zero evidence that gas ever traveled from the oil well to the water well.
But it doesn't the record indicate that whatever happened, it was because of what went wrong at the oil and gas?
No, Your Honor. There is zero evidence connecting the plaintiff's injuries in this case with anything that happened at the oil well.
So what
But
is
is
the
that
record?
what, sorry, go ahead.
Just what does the record indicate caused the problem at the water well then?
There is no evidence. I mean, you're talking about drilling 1,000 feet deep in oil and gas territory. You're going to find hydrocarbons in oil and gas territory when you drill 1,000 feet deep. I mean, so it is perfectly natural. The record does not indicate any link or any cause between the oil well and the water well. In fact, in their briefing, they say, well, the court should just assume it. The court should just assume that an oil and gas well drilled 1.5 miles deeper than a water well, that there was somehow communication between them. There is
But
no evidence of that.
did you move for no evidence summary judgment on causation? I didn't think that was before us.
Well, Chapter 95, I mean, I'm responding to arguments that are being brought up, but Chapter 95 and this court's jurisprudence have said that once Chapter 95 applies, the burden shifts to the plaintiff. We need only show that Chapter 95 applies. And there are 4 boxes to check to determine whether Chapter 95 applies. Is it an action by an independent contractor? Is the action against a owner of real property? Was it an action for personal injury or property damage? And did the injury arise from a condition or a use of the improvement upon which the contractor was working? All 4 boxes are checked under their own petition, and even at page 50 of their brief, they admit that they were injured by a condition of the water well.
I'm not sure the statute, though, says that the injury has to arise from the condition or use of an improvement. I think it says a claim for damages caused by negligence has to arise from the condition or use. So don't you have to look at where the negligence is?
Well, it says a claim that arises.
Right, and claim is defined to be a claim for damages caused by negligence.
I don't see how, under any objective reasoning, when the petition itself says our claim is that we were injured by the presence of gas in the water well, and in their briefing to this court, they say we were injured by the presence. Our claim arises from the presence of gas in the water well that was ignited. Now, under any objective view of those facts, one could claim that it didn't arise from the gas in the water well.
Well, that gets back to the question I originally asked you, which is, and the question Justice Lehrmann was asking you, which is, what condition or use are you looking at? If there are multiple conditions or uses of different things that are in the causal chain that are alleged, don't you have to look at the one that is alleged to be caused by negligence in order to decide, which in this case would be the use of the oil well, in order to decide if that prong of the Chapter 95 definition is met?
I would say that that's the big question here, is can we look at their pleadings, look at the true nature of it, look, as this court has done since Keach v. Kroger, and said all we do is look at the true nature of the pleadings. And the true nature of the pleadings was that there was a dangerous condition of the water well. And that was the presence of gas in it. And that because we were exposed to that dangerous condition, we have a cause of action.
So as long as you can find a condition that's between the alleged negligently caused activity and the injury, then Chapter 95 is going to apply?
No, I think if those 4 elements are met, if you look at the plain language of 95.002 and those 4 things are met, I mean, this court somewhat answered that question that you asked in Debra versus Cuevas, when it said there is no burden on a defendant in a Chapter 95 case to show that the use or condition of the improvement was the only cause. This court's already squarely rejected this idea that the defendant must somehow affirmatively disprove every other cause, that every other hypothesis. Remember, there's no evidence of cause. There's no evidence of any connection here.
Because there hasn't been a summary judgment motion on that ground, perhaps.
Well, the summary judgment motion is that Chapter 95 applies, and once Chapter 95 applies, the burden shifts to the plaintiff to put up some evidence to meet both of the elements of 95.003. That's what this court has said. I mean, those are the rules under which the litigants are playing the game, which is the rules that this court has said. That once Chapter 95 applies, if you can check all 4 boxes, which are undeniably checked here, once that happens, the burden shifts to the plaintiff to put up some evidence to get past 95.003. If that wasn't the case, there would have been no point in us even filing one. I guess we could have filed a different one, but.
Well, I suppose one of the questions in the summary judgment could have been, is this a negligent activity or a premises condition case? And then once you figure that out, then it's fairly easy to see how Chapter 95 applies.
Well, I mean, but again, we look to the true nature of the claim. And the true nature of the claim is what they say it is, which is that they were injured by a condition. They say that
I didn't see the
negligence
word
created.
condition, right.
No, actually, dangerous condition is throughout their petition. It is absolutely throughout their petition.
As is negligent activity. So,
Yes.
And I understand the point about, courts have to determine which one is correct. Is this a premises condition or a negligent activity? But sometimes evidence is relevant to that determination, like was the activity contemporaneous, right?
Well, and I would say that they did, in fact. They did provide evidence to attempt to show that it was contemporaneous, and that's pages 305 to 312 of the record. And
I think that's a different question. There may be evidence in the record that bears on whether the activity was contemporaneous, but did they know in the trial court that they needed to introduce evidence on whether it was contemporaneous?
They knew in the trial court that they had to introduce evidence to defeat Chapter 95, because that's what a Chapter 95 motion does. And their theory, their hypothesis for a way to defeat Chapter 95 is that there was negligence at the latest 3 days earlier. And negligence at the latest 3 days earlier. And mind you, Energen was not the contractor on the oil well. I mean, we have so many problems with this theory. Energen didn't do any of the actions on the oil well. There is not even an identified action of Energen's that is linked in any way to anything that happened on the oil well or anything that happened that was arguably negligent or any injury whatsoever. And I think this goes to the Texoga brief, which I think was a really well-done amicus brief from Melkonian and Fowler, which said that if we shift this now back to the oil and gas operators in this situation, oil and gas operators are not vertically integrated. They hire experts in their field at every step of the oil and gas production process. So to somehow say that...
And it may be that those people would be responsible rather than Energen at some point, but it doesn't seem like that's the issue we have before us right now.
Well, no, that is the point. They've sued those people, and those people settled. So we're left with a party who meets the elements of Section 95.02 on their face. And the question is, for this court, is can you then shift? Can plaintiffs plead around it? Can they just say, sure, that's true. We concede, essentially, that those 4 boxes are checked. But 3 days earlier, and again, there's not even an identified point of negligence, even with respect to the operator or the driller, which wasn't us. The only thing they say is that there was a gas kick. And a gas kick, all that means is they discovered pressure at 8,900 feet. When you are drilling for oil and gas, you're looking for pressure. This is not an extraordinary, unprecedented, unexpected event. You are, in fact, looking for pressure.
Is there evidence that Energen instructed as to the location of water sources and the depth of the well that could bear on whether they had control or knowledge of pressure in the well?
The evidence is that Energen never spoke to and did not contract with this subcontractor. This was a subcontractor of the original water well contractor. Now, there is evidence that Energen internally had discussions with respect to a target depth, and conceitedly that Energen spoke to the original contractor with respect to a target depth. But Energen had no relationship with, contractual, no communication with, never spoke with. The plaintiffs here said they never even spoke to or saw Energen. Energen wasn't even there. They didn't even know Energen didn't even know the water well company was there. They didn't even know they were there. There was no contact between them. Now, there were discussions with the previous water well contractor with respect to a target depth. And yes, that is true, and I would concede that. Just like if a business hired an independent contractor to build a building, you likely will tell them where on your lot you would like them to build a building. But that is the object of the contract, not the manner in which the contract is performed. And Section 95 goes, with respect to control, goes to the manner in which it was performed. The homeowner or the property owner has to control the manner in which the independent contractor's work was performed. And other than the ultimate object of it, which is a water well at a certain depth, there was no contact or no discussion with respect to the manner it was performed.
Any other questions? Thank you, Mr. Clinton. You'll hear from the respondents.
May it please the court, Mr. McNeil and Mr. Ham will present argument for the respondents. Mr. McNeil will open with the first 10 minutes.
Can we flip that? I think it's supposed to be Mr. Ham.
Yes, Mr. Ham
Thank you.
will proceed with the first 10 minutes.
May it please the court, counsel. I think it's pretty clear we're here today on a Chapter 95 issue. Opposing counsel didn't really get into some of the stuff that's in his brief that, seems to confuse this issue. This is not that difficult of a situation. This is a very straightforward question before this court, which is, does Chapter 95 apply to the plaintiff's negligence claims arising out of this incident that occurred out in Reeves County? Under the well-established rule, the burden is on the respondent as the property owner to establish that Chapter 95 applies. Under that burden, Energen is required to conclusively establish each of the elements of an affirmative defense under Chapter 95, which they do not do. I think the justices have already touched on the fact that the record was lacking of the evidence needed to carry that burden, and because of that, Chapter 95 didn't apply. But perhaps the clearest reason and the clearest way for this court to rule on this matter and to affirm the Court of Appeals decision is that under INEOS, you got to have the same improvement that you're working on is the improvement that caused your injuries. And here it's very clear that we have a water well that the plaintiffs were working on, and you have an oil well that's approximately 500 feet away. I think somewhere in the Court of Appeals opinion it says 500 yards, but that's not correct. It's 500 feet. So you're talking nearly 2 football fields difference between where these two improvements are located. You've got one that's part of the surface estate that's owned by multiple surface owners. And then you got the other improvement, which is an oil and gas well. The minerals are owned by the state of Texas, and the leasehold rights belonged to Energen at the time before they were acquired. And you have 2 different improvements, which is very clear under INEOS and the cases that were right before that. And that's the precedent that the Court of Appeals followed, and that's what we've argued throughout this process, is that we were injured while we were working on an oil well that had nothing to do, while we were working on a water well that had nothing to do with an oil well. And what I think needs to kind of be explained, and it's all in the record, because we did, despite what Energen might argue, the record does have evidence of the communication between the oil well and the negligent activity occurring at the oil well that eventually gets into the borehole of the water well and comes up to the surface. So approximately 2 to 3 days before the water well explosion, Elite drillers hits the aquifer that they were instructed to drill down to, approximately 900 feet. And when they do that, they mud up. And when they hit that aquifer, there was no gas coming up that hole. So they mud up just like they do every other time. And then they start running the casing down and welding the joints. And so you got sparks, you got everything, no fire coming. And then if you look at the reports, the daily drill reports that Energen produced in the case, some of which were actually prepared by the drilling contractor, the mud man, they show over the 2.5 days, the multiple hours before that, you get a large gas kick down like near 9,000 feet. You have lost circulation, lost returns, you've got mud, gas going out into the formation. This all is occurring at a time when the well is actually flowing. And the records, the notations on the reports talk about it flowing, that even at one point turned on the flare, which I don't think was on at the time that the incident happened. But in that 2.5 day period, you have all these issues going on. And they're cited in the brief and in the record, but Energen, or the driller, the water well driller, comes back in to complete that water well on the 17th of January. When it goes in there, just like normal, runs an air compressor down, and as soon as it blows that mud cake that's holding the water back, right away. There's gas, it's shaking. The driller, Mr. Wallace, he's yelling for everybody to run. He's trying to shut off the rig, and then boom, big ball of fire engulfs it. He's burned, equipment's destroyed. But the key is, and there is evidence in the record that there was not gas approximately 2.5 days before. There was gas at the time this happens, and then the drilling reports show all these issues occurring at the well and all this lost circulation, lost returns, things of that nature. So there is evidence to show, and it's, natural gas it's not naturally occurring in an aquifer down at 900 feet, right? And so it wasn't there before, and then all of a sudden it's there. So it's like fraud. You're not gonna just be able to, drop a dye in there and see where the dye comes out, like we were gonna do a test on a person. You have to use circumstantial evidence. You have to read the different factors that are going into this. And so that's where the Court of Appeals determined, yes, we did provide sufficient evidence to create a fact issue on the connection there and the negligent activity or at the oil well. And so,
Now, was anything going on at the oil well at the time of the explosion at the water well?
yes, sir, they were continuing to drill, and as soon as that happened, they shut down for about 4 hours, and then after 4 hours, according to the drilling reports, they resumed drilling. So they did a brief pause, and then this water well burned for several days.
The way you pleaded the case is that the striking the gas kick sometime prior to the gas explosion at the water well, getting the gas kick, that somehow is what triggered the migration of the gas into the water well bore?
Yes, Your Honor, and it's, scientific, there's experts in the case, but there's also in the record, and the Court of Appeals picked up on it, there was also cement issues that our expert found, and the expert went into it, but as a combination of the gas kick, the cement issues, I think, I guess gas getting back behind the pipe, that's where, over that course of that time it happened. But the thing about it is that once that kick occurred, the lost circulation, lost returns was a constant ongoing battle that was taking place. And so, and that goes to the whole contemporary negligence aspect of this case, that, there's case law that it doesn't have to, as soon as that kick happened, it doesn't have to be when the injury occurred. It has to be both near the time and location. And in light of, we're 500 feet away, the migration of this gas, from a well that they were down at about, I think, just above 9,000 feet, that is a contemporaneous situation that occurred, and it was continuing to occur. So it's not like there was one loss. I mean, you look at the entries that we've cited, many of them, and it continued, and they couldn't get it under control, and they were working, throwing lots of mud into the hole, trying to get this thing under control. And in that time period, the flare's not on, and the well's flowing. So if the flare's not on, the well's flowing, that gas is going somewhere, right? And the fluids were coming, not coming back to the surface, so they were being lost out into the formation. And so, we've shown that contemporaneous negligent aspect of this case to create a fact issue that this occurred because of the negligent activity at the oil well. And I think the other thing is,
would you point us to define when a contemporaneous activity ceases? You mentioned that it's near the time and location. Do some of the cases also look at whether the force has come to rest or something like that? I'm trying to remember. This wasn't well covered in the briefing, and that's not a criticism, but I don't remember what the factors are on that.
Yeah, I think it's a fact by fact situation based on the circumstances. Because there's the Keach case, which is cited, for the whole premises defect versus negligent activity, and that's something where you spray a plant and then the floor is slippery. Well, that's going to be much more contemporaneous because that supermarket, within 30 minutes, I think was kind of the time frame there. Here, you've got to, because of the oil well and the water well, for them to communicate, 9,000 feet, I think in the reply brief that says about 1.5 miles, that's some time for that to gradually go. And then there's some other hydrologist type language about the effects of how water flows up in a aquifer. But, the thing about it is it's within hours of this happening. So, and it's the other issue here is you can't really pinpoint exactly when this type of thing happened because it's happening 1.5 miles under the earth. And so that's where, there's difficulties, but there's also, legal doctrines to help try to establish and connect those dots. And that at least creates our fact question that the trial court, got wrong and find that Chapter 95 applied. Because...
Sam, what was Energen's role in managing the loss in pressure at the oil well?
Well, they had Neighbors was their drilling contractor, and I believe the evidence is that they would get the copies of the daily drilling reports, so they were seeing what was going on. Neighbors, Energen, my understanding, they contracted out everything they did. They didn't sit on location with their own employees, and so, and I think they're based out of Alabama maybe, so the drilling contractor is sending the reports daily back to Energen. And on the oil well, that's, we had nothing to do with that. We weren't hired for that. I don't think the plaintiffs ever set foot on the oil location. But going to what opposing counsel said about Energen had no knowledge or involvement on the water well, that's just not correct. Because Elite got down to the TD, the depth that Energen's hydrologist had said, or geologist, where we need to go complete this. And at that point, there was a several-day period where Elite then had to wait on Energen to make a decision of, yeah, let's go ahead and complete it at this point. And so Energen was much more involved in the testimony, which we've cited. Both their senior engineer and their senior geologist, is very clear that they were involved in what was going on, and they knew what was going on out there.
Any other questions? Thank you, Mr. McNeil.
Thank you.
Mr. Hammond, we'll hear from you.
Mr. Chief Justice, may it please the court and counsel, and I also want to thank you for the opportunity to split argument with Mr. Ham. And thank you for your questions you asked earlier. I'd be happy to answer any follow-up questions, but there's three main issues that I believe are in front of this court in this case. So number one, was the oil well and the water well the same improvement or not? And that's looking at Ineos and then the recent case of Valdez. Can you impute one improvement to the other? And as this court stated in Valdez, the primary consideration there is proximity. In Valdez, you got an overhead power line that I'll assert the property owner had nothing to do with. It was there on an easement by the power company. It's open and obvious, and it's right above where they're putting the pilings in. In that case, the court imputed the improvement of the power line and its condition to the piling, which was right underneath it, close enough for a 20-foot piece of rebar to hit it. To use Valdez in this case, we would have to extrapolate that proximity from 20 feet to 500 feet on a horizontal basis, two separate and distinct boreholes into the surface of the earth, and we would have to impute the condition of the oil well to the condition of the water well. And we assert that that proximity is a step or 500 too far. That is not close enough to impute what was going on at the water well to the oil well and vice versa. So I think that's the first issue. The second issue is we do have evidence in this record. Mr. Ham went into detail, and it's there. We have evidence that there was a contemporaneous use and activity at the oil well, separate and apart from anything that was going on at the water well. 500 feet away by a different party, they were taking affirmative actions that we have alleged, and in some respects, Energen has admitted, was negligent. So you get to the distinction that this court did in Abatoon, sorry for the pronunciation. There is a distinction between, as Your Honor was saying before, there's a distinction between a premises defect claim, which is, I believe the court said, was a non-feasance-based claim. It just is what it is. And is that the basis of your claim? But this court recognized in Abatoon that there's also a malfeasance theory of recovery, and that's what we have here. I will respectfully disagree with counsel. The true nature of the plaintiff's pleadings in this case is not premises defect. It is an activity or an instrumentality that was affirmably taken by Energen 500 feet away and that caused our damage. That's our claim. It was not just a latent existing condition in the water well that forms the basis of our claim. It was an activity and instrumentality at the oil well, and that's a very important distinction, and Abatoon recognizes that distinction.
But isn't that ultimately the case in most premises liability scenarios. If the if the condition is that there's this hole that got dug that didn't get buried or warned against properly, well, at some time before that, somebody dug the hole. I mean, there's all here, and this gets to the artful pleading argument that your opposing counsel makes, which is, it seems to me you could have pled this case, legitimately good faith pleading, either as there's a dangerous condition in the water well that caused the harm, and that being the presence of gas. Or you could have pled it as they negligently drilled the oil well in a way that allowed for the escape of gas a few days earlier. Either one of those are legitimate good faith methods to plead these claims?
Sure.
So you just get to pick which one you want in order to avoid Chapter 95?
No, Your Honor, we don't. We have to work with the facts we're given. And it happens in this case. It'd be one thing if at the time we started drilling the well, that gas was already in the aquifer, but it was not. As Mr. Ham said, when they first drilled it and mudded up the hole, there was no gas. It happened while our client was over the hole, drilling and completing that well, using a welder, welding that metal casing. That's when the gas migrated. So on the artful pleading argument, as a plaintiff's lawyer, sometimes I wish I could create my facts, but I can't. I can't create a timeline. I have to work with what I have.
It seems like it's the court's role to police whether it's whether it's properly as a legal matter a negligent activity or a premises condition case, and courts make that sort of determination all the time. So what, we have the facts as you've pled them, and it seems like then it's the court's task, when properly called upon by the parties, to say, is this a premises case or is it a negligent activity case? And then you can apply Chapter 95 from there with more clarity. But what would you say as to why we should consider this to be a negligent activity case and not a premises case?
Because we have evidence of contemporaneous activity by Energen on a separate improvement. The best analogy I can come up with, Your Honor, is if we got a commercial ranch that entertains people, and I'm hired to go do some tile work in this big barn, and I'm sitting there. 500 feet away, the owner of that ranch decides he's going to start digging a foundation for a new ranch house. He encounters some rock. So he goes and gets this big old box of dynamite, and he puts it in there, and he blows that rock up at the time when he can see 500 feet away that my truck's at the barn, just like, frankly, the guy Energen at the oil well could see the water well rig 500 feet away. This is Pecos, Texas. It's flat. It's wide open. You can see them there. There's evidence that they knew they were there. If that owner, at the time I'm working on a separate improvement, takes an affirmative action on a separate improvement, and that causes my injury, it takes it out of the premises defect claim and it puts it in contemporaneous negligence. So to answer your question, yes, you look at what the facts and allegations are in our pleading. Energen had the burden to establish that Chapter 95 applies. That is their burden. And once they meet that burden, then it does shift, and we've got to prove control and actual knowledge, but we never get there here because under Abitune, the court has to look on, is it more of a non-feasance premises liability case? In other words, what you are hired to work on, is it inherently of the nature that you should anticipate what you're going to encounter? And I think the law, and I agree that the law is, we're going to put that on the contractor. If you should know what you're going to encounter drilling an oil well naturally, without the superseding cause or influence of another party or action. That's on you. But under this case, you've got contemporaneous actions of Energen causing that condition at the water well to change at the time we're there. It moves it to the contemporaneous negligence, and that's what Abitune says.
So under that way, how do we decide whether something is contemporaneous enough? Because on a construction project, for example, the job site changes every single day, so we can't just measure it according to what the job site looked like on the day construction began. So how would you suggest we formulate a test to decide whether something's contemporaneous?
It's the whole concept of drawing the line. kind of drawing the line of what makes the same improvement to different. I would say, as Mr. Ham said, the case I read, contemporary, it doesn't have to be on the second exactly. It just has to be near in time and space to be deemed contemporaneous. And Your Honor, I think you said something, no intervening factors come in to stop that contemporaneous action. Nothing has superseded that. But Your Honor, in this case, this is what's even more incredible. In this case, as far as contemporaneous, we had two main theories of negligence. Number one, they knew the gas was coming back in that oil well, and they should have stopped drilling right then there. They should have stopped releasing the gas. But the second one is, they failed to warn us. We've got a failure to warn case. They know we're 500 feet away. They can see our water well rig, and we're drilling. You got exhaust smoke coming out of the engine. We are drilling. Their own engineer, the head of the project at Energen, said, he basically admitted, a reasonably prudent operator would have warned a water well driller of the gas and the conditions at the oil well. We would have had them stop drilling that water well. But they didn't do it. And I'll respectfully disagree with opposing counsel that they didn't know our clients were on the water well. We were. We were open and obvious, unlike the natural gas underground. We didn't know the gas was there, and that's why the malfeasance theory applies.
Any other questions? Thank you, Mr. Ham.
Thank you, Your Honors. Thank you.
Mr. Clinton, if the facts as alleged and actually proven in this case were all the same with regard to the activity that had gone on and allegedly was going on at the oil well at the time of the explosion, but you changed the facts in this respect. Instead of the gas allegedly migrating underneath down into the well bore of the water well, instead it had come up out of the oil well, migrated, hovering along the surface, and exploded along the surface, caught fire, and you know, like if you pour gasoline and you light it, it goes out, right, because it's a little heavier, and injured the people working on the water well. Would that change? Wouldn't that clearly be a question of contemporary negligence at the oil well? There's nothing about the condition of the water well in that hypothetical. And the only difference here is, well, it just happened to have migrated into the water well instead of above the water well, which then gives you the opportunity to argue, therefore, it's necessarily a condition of the water well that caused the harm. See what I'm saying?
I think I follow your question. I mean,
But with regard to what was happening, the contemporaneous activity at the oil well, it doesn't change that at all.
Well, I mean, I think the closest case to that is a Budahone, in which is pretty similar, in which the court said that Chapter 95 does apply. It was the asbestos that kind of floated nearby the contractor, and the court said that 95 did apply. I would also point the court to Los Compadres Pescadores versus Valdez. I think this is, you know, when I had readers read the briefs for me, and they read Los Compadres and literally highlighted this sentence in Los Compadres and says this answers the case. This is how you test for whether a condition of an improvement is what is the one that the claim arose from. This is what the court said at page 785. If a dangerous condition, by reason of its proximity to an improvement, creates a probability of harm to one who constructs, repairs, renovates, or modifies the improvement, it constitutes a condition of the improvement itself. That's it. The box has been checked under this court's test for how you determine whether a claim arises from a condition. I would also note footnote 10. It's actually even closer on point. Footnote 10 at page 783. The fact that the power line was energized could also qualify as a dangerous condition of the power line. So had the power line been the thing that they were working on, the court says, obviously that would have been a condition that would have triggered Chapter 95. Here you have the water well with gas inside of it. That there's no objective distinction between electricity and electric line and gas in a water well.
Except that
either
there
way.
was nobody working on the electric line at the time in Los Compadres, right?
Well, I mean, True, but this whole theory is a hypothesis. There's plaintiffs have stood before the court and said there's an expert report in the record. I dare you to find it. It's not there. There's no expert report in the record. There's no cement job evidence in the record. It's not there. The only evidence that they point to is that there was contemporaneous activity at the time. Yes, there was drilling, not by us. And to answer Justice Bland's question, the answer is no. We had no mechanism for handling a gas kick at the oil and gas well. We weren't there. It wasn't our job. We had hired an independent contractor who's an expert in that. This idea that we somehow pushed gas into the water well is absurd. Gas doesn't get pushed in. A gas kick is something that happens from the formation, not something that happens to the formation. We are not injecting gas into the formation.
It's like that'd be something good to have evidence from experts in the record on.
I agree, and when the burden shifts to the plaintiff to have some evidence to support their claim, they should do so. This court has said time and again, Chapter 95, once it applies based on this test in Los Compadres Pescadores, which we have clearly met because it was something that posed a probability of harm to someone in proximity to the improvement. That's the test. And once you hit it, the burden shifts to the other side, to the plaintiff to come up with some evidence to meet the two prongs of 95.003. We were not there. They keep on saying it's 500 feet away, so we saw them. We were not there. There was no Energen employee on the site. That's in the record. We were not there. We did not talk to them. They did not see us. They never spoke to us.
That would be a different motion for summary judgment though, right, than what we're here on today?
Yeah, I mean, I'm responding to their arguments that we should have known because we were there, but we weren't there. I mean, I'm having to respond to things that I agree with your kind of side arguments to the real issue here. The real issue here is when the 4 boxes are checked, can the plaintiff nonetheless plead around 95 by pointing the finger back at the property owner and saying your negligence created the condition that harmed us? And Energen's position is that you can't. Thank you.
Any other questions? Thank you, Mr. Clinton. Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.